ready for reading and start. Learned counsel for the respondent, on the other hand, contended that there is no apparent error in the judgment of the High Court in quashing the criminal proceeding on the ground of limitation stop. The High Court has correctly treated the handwritten notice sent by the appellant on 27th April 2012 as a valid notice in terms of section 138 of the Act, as the appellant had given the notice in writing within 15 days of information stop being aggrieved by the judgment and order so passed by the learned single judge. The landowners are before us in these appeals stop. We have heard Shri Singh and Shri Kumar, learned senior counsels, appearing for the appellants, and Shri Singh, the learned counsel for the state. Stop. The learned single judge is the impugned judgment and order has not awarded interest on the said amount. Stop. We are of the opinion that, in view of the Constitution bench decision of this court, the learned judge ought to have granted interest on the said amount stop. In view of the above discussion, we allow these appeals modify the order passed by the learned single judge and remit these appeals to the reference court to determine the compensation payable to the landowners in the light of the judgment and order passed by us in these appeals stop. We further direct the reference court to complete this exercise as early as possible, at any rate within higher limit of 6 months stop. The primary question for consideration in all these appeals is whether the respondents were entitled as of right to one more opportunity to switch over from the contributory provident fund scheme of which they were members to the pension scheme and the general provident fund scheme implemented by the appellant with effect from 28th November 1988 stop. Broadly speaking, the contention of the respondents is that they were aware of the switch over option since they were posted in remote areas of Punjab, while the contention of the appellant is that a large number of opportunities extending over 8 years were given to the respondents to exercise the switch over option and that they could not claim any right to any further opportunity to make the switch over stop. Being aggrieved by the decision of the learned single judge, the board preferred writ appeals before the division bench of the High Court stop by a judgment and impugned order. The High Court dismissed the appeals, relying entirely on the elaborate order passed by the learned single judge stop. It is under these circumstances that the present batch of appeals preferred by the board is before us stop. For the sake of convenience, a summary of the various notices issued by the board are put down in the form a chart stop. The order was followed in several other writ petitioners filed by aggrieved employees, and they made as many as 30 representations stop.